So students, the first important judgment of part 2 important judgments of 2023 is Ashutosh Samantha versus Ranjan Baladasi. In this case, it was decided by court that no presumption on legality of will even if it is too old. So when we talk about section 90 of Indian Evidence Act, it says that if there is any particular document that is more than 30 years old, then it will be presumed by court that that document is genuine in nature. But when we talk about will, it is said by the court that we cannot presume, even if the will is more than 30 years old, all the procedures, all the provisions of Indian Evidence Act and Indian Succession Act will be used to say that whether the document is genuine or not. You will have to prove before the court that that will is totally genuine in nature. So students, let's move to the second judgment. The second judgment is Shilpa Shailesh versus Varun Srinivasan. So what happened in this case? Power of Supreme Court to grant divorce under Article 142. So in the history of Supreme Court, this was the first time in which Supreme Court used powers under Article 142 to grant a divorce. So you must have seen, students, that there is one particular term that appeared in mock test also, in your books also, irretrievable breakdown of marriage. So when we talk about Hindu Marriage Act, according to section 13, all the grounds are mentioned on which you can take a divorce, and in those grounds, irretrievable breakdown of marriage is not mentioned. So when we talk about this judgment, Supreme Court said that if there is irretrievable breakdown of marriage, then we have power, Supreme Court have power to grant divorce. But again, at the same time, Supreme Court said that you cannot approach Supreme Court or High Court under Article 32 or 226 respectively to ask for divorce. Also students, in this case, Supreme Court said that when we talk about section 13 of Hindu Marriage Act, in that it is mentioned that even if the divorce is by mutual consent, then also a cooling period of 6 months needs to be there. So Supreme Court in this case guided that it needs to be waived off if the divorce is by mutual consent. So overall, in this case, it was decided that Supreme Court have power under Article 142 to grant a divorce if there is an irretrievable breakdown of marriage. The third important judgment is Naeem Ahmed versus NCT of Delhi. So in this case, it was discussed that whether the promise to marry and eventually not marrying and having a sexual relationship with the other person will amount to rape or not. So when we talk about this case, so court have said that when we talk about or when we are giving a judgment, so if there are a particular person who had sexual relationship with the other person, or they entered into a sexual relationship on the promise of getting married, but eventually they are not getting married, whether the male will be liable for the crime of rape or not. So court said that other factors also needs to be taken into consideration. And when we talk about the promise to marry, it should it should be reflected from the facts of the case that the primary promise was fraud in nature. The primary promise was not genuine in nature. If the primary promise is genuine in nature and because of some other factors the person is not able to marry the other person, in that case the person will not be liable for rape. In this case, what happened? The person was sentenced for 10 years of imprisonment and he was liable for rape. But Supreme Court said that when we talk about the facts of the case, we can say that at the point when they entered into a sexual relationship or when they entered into consensual sexual relationship, at that point the intention of man was very clear that he wanted to marry a girl, but eventually due to some circumstances, if he is not able to marry, then we cannot hold him liable for rape. Students, next important judgment is Siddharuda versus State of Karnataka. In this case, concept of marital rape was discussed. So the main conflict was when this particular incident or when this particular case happened, it was in 2012. At that point of time, law was saying that if the girl is above 15 years of age and she is married, then there will be no rape according to the definition if there is non-consensual sex with his own husband. But when we talk about the current law, it is saying that if the girl is above 18 years of age, then only there is an exception. Otherwise, it would amount to rape. If the girl is 16 or 17 years old, then even if his husband is having sex with her, non-consensual sex with her, then that would amount to rape. So the conflict was which law needs to be applied. So finally, court said that when the case was filed, when this incident happened, we need to take into consideration law of that time. So if according to that law, it was not a rape, so according to the current situation also, we'll have to apply that law that was prevalent at that point of time. So it was decided by court that the husband is not liable for rape. So students, next important judgment is S.K. Khaja versus State of Maharashtra. In this case, what exactly was discussed? What is the relation between attempt to murder and injury? So if there is any particular person against whom an allegation is there that he is liable for attempt to murder, but the injury that have been caused to the person, the victim, whether that needs to be taken into consideration to decide whether there is an act of attempt to murder or not, whether there is a crime of attempt to murder or not. So it was decided by court that we are deciding on the parameter the act the person is committing. If you have done each and everything that you must have done to commit that crime, so we are only concerned with that. The resultant damage that have been caused to the other person should not be taken into consideration to decide the crime. So it was decided by the court that even if the injury that have been done to the other person is very superficial nature or is very of nominal nature, the damage that have been caused, even then the person will be made liable for attempt to murder if you have done each and everything that must have done by him to commit that crime. So students, this was all with respect to today's session. In today's session, we discussed 5 important judgments. This was the part 2 of important judgments of 2023. We have discussed the part 1 earlier. So in total, you have 10 important judgments that you have to read for your CLAT examination. Again, the bottom line will remain same, that you don't have to mug up each and everything. The objective is that you should be familiar with these topics if these passages come in the actual examination. Best of luck. Thank you.